Hello everyone, my name is Laxmikanth. In the last class, we have started a new chapter, Fundamental Rights, and dealt with right to equality. In this session, we'll deal with right to freedom, that is Article 19 to 22. Okay, right to freedom consists of Article 19, 20, 21, 21A, and 22. Okay. First, protection of six rights. Okay, Article 19 guarantees to all citizens six rights. What are they? Right to freedom of speech and expression, that is 19(1) clause A. Right to assemble peacefully and without arms, clause B. Right to form associations or unions or cooperative societies, 19(1) clause C. Right to move freely throughout the territory of India. Okay, not only the Union of India but throughout the territory of India, that is clause D. Right to reside and settle in any part of the territory of India. Right to practice any profession or to carry any occupation, trade or business. This is not F but this is G. Okay, 19(1) clause G. Okay, 19(1) clause F was right to acquire, hold and dispose of property. That was deleted by 44th Amendment Act of 1978. So under Article 19, it guarantees only six rights to all citizens. Okay. Next, we'll see all these six rights one by one now. See, originally Article 19 contained 7 rights, but the right to acquire, hold and dispose of property was deleted by 44th Amendment Act of 1978. So these six rights, now we have only 6 rights under Article 19. These 6 rights are protected against only the state action and not the private individuals. In the last class we have seen, right, some of the fundamental rights are protected against only the state action. Some are protected against both state as well as private individuals. Okay, these 6 rights are protected against only the state action but not against the private individuals. Next, moreover, these rights are available only to the citizens and to the share company but not to foreigners. Okay, Article 19 is available only to citizens but not to foreigners. Next, the state can impose reasonable restrictions on the enjoyment of these 6 rights only on the grounds mentioned in the Article 19 itself and not on any other grounds. Okay, reasonable restrictions are imposed on the 6 rights which are mentioned under Article 19. Okay, let us see what are they. First, freedom of speech and expression. It implies that every citizen has a right to express his views, opinions, beliefs, and convictions freely by the word of mouth, writing, printing, picturing, or in any other manner. Okay, freedom of speech and expression. This is expressed either by mouth, writing, printing, picturing, or any other manner. Supreme Court held that freedom of speech and expression includes the following. Okay, Supreme Court said the following are included in the freedom of speech and expression. What are they? Right to propagate one's views as well as views of others. Propagating one's views as well as views of others. Next, freedom of press, freedom of commercial advertisements, right against tapping of right against tapping of telephonic conversation, right to telecast. That is, government has no monopoly on electronic media. You need not take the permission of government. Okay, you can telecast. There are many public channels, right? So they have the right to telecast. Government has no monopoly on electronic media. Right next, right against bandh called by political parties or organizations. right to know about the government activities, RTI. Okay, right to information. We can know the we have the right to know about the government activities. Next, freedom of silence, right against imposition of pre-censorship on the newspaper. Okay, right to demonstration or right to demonstration or picketing, but not right to strike. Right to demonstration or picketing. You can come out of the work if you didn't like it, but you don't have right to strike. Okay, all these are held by the Supreme Court under freedom of speech and expression. Next, the state can impose reasonable restrictions on the exercise of freedom of speech and expression on the grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. Okay, the 6 rights state can impose reasonable restrictions on the grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency, morality, contempt of court, defamation, and incitement of an offense. Next, freedom of assembly. Okay, freedom of assembly. Every citizen has a right to assemble peacefully and without arms. It includes the right to hold public meetings, demonstrations, and take out positions. This freedom can be exercised only on public land, and the assembly must be peaceful and unarmed. Okay, under this freedom of assembly, every citizen has a right to assemble peacefully and without arms, and this can be exercised only on public land. Okay, next, the state can impose reasonable restrictions. However, there are some restrictions. Okay, these restrictions are on 2 grounds. What are they? Sovereignty and integrity of India and public order. Okay, on these 2 grounds there are some reasonable restrictions. See, including the maintenance of traffic in an area. If there is any some assembly like gathering of people on the roads, if it is causing some traffic, okay, it is causing some traffic, then restrictions are imposed on this meeting. Okay, next, under section 141 of the Indian Penal Code, as assembly of 5 or more persons becomes unlawful. Freedom of assembly is there, but under this section 141 of Indian Penal Code, the assembly of 5 or more persons becomes unlawful if they resist the execution of any law or legal process. Okay, if they doesn't follow any legal process, then it becomes unlawful. Next, to forcibly occupy the property of some person. If they forcibly occupy property of any person, then also it becomes unlawful. Next, to commit any mischief or criminal trespass. If they commit any criminal activities, then also it becomes unlawful. Next, to force some person to do. If they force anyone to do illegal act. Okay, if they force anyone to do some illegal act, then also it becomes unlawful. Next, to threaten the government or its officials on exercising lawful powers, then also it becomes unlawful. Next, freedom of association. All citizens have the right to form associations or unions or cooperative societies. It includes the right to form political parties, companies, partnership firms, societies, clubs, organizations, trade unions, or any body of persons. Okay, this is under freedom of association. However, there are some reasonable restrictions. This can be imposed on the exercise of this right by the state on the grounds of sovereignty and integrity of India, public order, and morality. Reasonable restrictions are imposed under 3 grounds. What are they? Sovereignty and integrity of India, public order, and morality. See, the right to obtain recognition of the association is not a fundamental right. Okay, right to obtain the recognition of the association is not a fundamental right. That means they are not enforceable by the court. Okay, next. Freedom of movement. This freedom entitles every citizen to move freely throughout the territory of country. Okay, this freedom of movement entitles every citizen to move freely throughout the territory of a country. He can move freely from one state to another state or from one place to another within the state. Okay, state to other state or within the state. Thus, the purpose is to promote national feeling and not parochialism. What is parochialism? Nothing but narrow-minded. See, for example, if we stay in a community, okay, we feel responsible only to that community. If anything happens in other community, we just don't bother. That state of mind should be changed. So, to promote the national feeling, this freedom of movement was included. Next, the grounds of imposing reasonable restrictions on this freedom are two. Again, these reasonable restrictions are imposed on two grounds: the interest of public, general public, and the protection of interest of any scheduled tribe. Okay, two reasonable restrictions are interest on general public and protection of interest of any scheduled tribe. The entry of outsiders in tribal areas is restricted to protect the distinctive culture, language, customs, and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. Okay, see, the entry of outsiders in tribal areas is restricted to protect the culture, language, customs, and manners of the scheduled tribes and also to safeguard their traditional vocation and properties against exploitation. Okay, next, the Supreme Court held that freedom of movement of prostitutes can be restricted on the grounds of public health and in the interest of public morals. Okay, next, the freedom of movement has two dimensions. What are they? Internal and external. Internal is right to move inside a country, external is right to move out of the country and right to come back to the country. So, freedom of movement has two dimensions, internal and external. Article 19 protects only the first dimension, that is only internal movement. The second dimension is dealt by Article 21. Article 21 is right to life and personal liberty. Okay, Article 19 protects only the internal movement. Article 21 deals with the external movement. Okay. Next, freedom of residence. Every citizen has a right to reside and settle in any part of the territory of India. This right has two parts: the right to reside in any part of a country, which means to stay at any place temporarily. Okay, right to settle in any part of a country, which means to set up a home or domicile at any place permanently. Okay, to reside means to stay temporarily, to settle means to stay permanently. The state can impose reasonable restrictions on two grounds. Okay, reasonable restrictions are imposed on two grounds. What are they? In the interest of in the interest of general public and protection of interest of any scheduled tribes. Okay, reasonable restrictions are imposed on interest of general public and protection of interest of any scheduled tribes. The right of outsiders to reside and settle in tribal areas is restricted to protect the distinctive culture, language, customs, and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. Same restrictions which was given under freedom of movement. Okay. Next, in many parts of country, the tribals have been permitted to regulate their property rights in accordance with their customary laws, rules and laws. Okay, in many parts of a country, the tribals are given permitted to. In many parts of country, the tribals have been permitted to regulate their property rights in accordance to the customary rules and laws. The Supreme Court held that certain areas can be banned for certain kind of persons like prostitutes and habitual offenders. Habitual offenders are nothing but persons who create a theft or create public disturbance, etc. regularly. Okay, or they can be banned in certain areas. Okay. Next, freedom of profession. All citizens are given right to practice any profession or to carry on any occupation, trade or business. This right is very wide as it covers all means of earning one's livelihood. Okay, the state can impose reasonable restrictions on the exercise of this right in the interest of general public. Okay, reasonable restriction is imposed in the interest of general public. See, further, the state is empowered to prescribe professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade and business. State is empowered to prescribe the professional or technical qualifications, okay, for practicing any profession or carrying any occupation, trade or business. Next, state is prescribed to carry on by itself any trade, business, industry or service, whether to the exclusion of citizens or otherwise. Okay, state has a right to carry on by itself any trade, business, industry or services. Next, this right does not include the right to carry on professional business or trade or occupation that is immoral. Okay, right to profession does not include the right to carry profession or business or trade or occupation that is immoral, that is trafficking in women or children, okay, harmful drugs or explosives, etc. The state can absolutely prohibit this or regulate them through licensing. The state has a power to prohibit them or regulate them through licensing. Next, protection in respect of conviction for offences. Article 20. Okay, it grants protection against arbitrary or excessive punishment to an accused person, whether the citizen or foreigner or legal person like a company or a corporation, whatever it might be. Okay, Article 20, it grants a protection against arbitrary and excessive punishment to the accused person. It contains 3 provisions: no ex post facto law, no double jeopardy, no self-incrimination. No self-incrimination. Okay. Now let us see what is no ex post facto law. No person shall be convicted of any offence except for the violation of law in force at the time of the commission of that act. See, for example, if a person committed some crime, okay, we know that it is offence, but at the time when he committed the crime, there is no law to punish him under that crime. Then will that person get punished? No. Though we know that it is an offence, but there is no law, so this person is not punished. Okay, that is what the statement says. No person shall be convicted to any offence except for the violation of law in force at that time of the commission of an act. Next, subjected to the penalty greater than prescribed by the law in force at the time of commission of that act. Suppose a person committed crime and he is given 2 years of imprisonment. Okay, then this person only is punished for 2 years. He should be in jail only for 2 years and not more than that. Okay, that is the meaning of this statement. Next, no double jeopardy. No person shall be prosecuted or punished for the same offence more than once. Clear? He should not be punished for the same offence more than once. Next, no self-incrimination. No person accused of any offence shall be compelled to be the witness against himself. Okay, no person is compelled to be witness against himself. This is called no self-incrimination. See, an ex post facto law is one that imposes penalties retrospectively. Okay, what is retrospective? See, upon the acts already done or which increases the penalty of such acts from the starting. For example, if there is a person who is already under the punishment, he is imprisoned for 2 years. He already completed 1 year of imprisonment. Now there is some change in the law, and the offence the offence made by him is punished for 5 years of imprisonment. Then this person again, he will continue. His 2 years imprisonment is continued to 5 years. That is retrospective. Okay. The enactment of such law is prohibited by the first provision of Article 20. This earlier ex post facto law was retrospective, right? And this was prohibited by the first provision of Article 20. Next, this limitation was imposed only on criminal laws and not on the civil laws or tax laws. That is, civil laws or tax laws can be imposed retrospectively, but criminal laws are not imposed retrospectively. Okay, further, again, this provision prohibits only conviction or sentence under the ex post facto criminal law and not on the trial thereof. Understand? See, first ex post facto, it was imposed retrospectively, but this was prohibited by the first provision of Article 20. Next, there was a limitation that is imposed only on a criminal laws and not on the civil laws. Okay, the retrospective is prohibited only on the criminal laws, but is imposed on the civil laws. Further, again, this provision prohibits only conviction or sentence under the ex post facto criminal law and not on the trial. Okay, these limitations are imposed only on the ex post facto criminal laws. Finally, the protection under this provision cannot be claimed in case of preventive detention or demanding security of a person. Okay, protection under this provision cannot be claimed in case of preventive detention or demanding security of a person. Okay, next. The protection against double jeopardy is available only in proceedings before the court of law or judicial tribunal. Okay, the protection against double jeopardy is available only in the proceedings before a court of law or judicial tribunal. In other words, it is not available in proceedings before departmental or administrative authorities, as they are not of judicial nature. Protection against double jeopardy is available only in the proceedings of court of law or judicial tribunal, but not before departmental administrative authorities. Next, the protection against self-incrimination extends to both oral evidence and documentary evidence. Okay, the protection against self-incrimination is extended to both oral evidence and documentary evidence. However, it does not extend to compulsory production of material objects. Next, it does not extend to compulsion to give thumb impression, specimen signature, blood specimens, etc. Next, it does not extend to compulsory exhibition of a body. Okay. Though it is extended to both oral evidence and documentary evidence, it doesn't extend to these three provisions. Okay. Further, it extends only to criminal proceedings and not to civil proceedings or proceedings which are not of criminal nature. Okay, self-incrimination is extended only to criminal proceedings and not to civil or proceedings which are not criminal in nature. Okay. Next. Protection of life and personal liberty. Article 21. It declares that no person shall be deprived of his life or personal liberty except according to the procedure established by the law. Okay, Article 21 declares no person shall be deprived of his life or personal liberty except procedure established by law. This right is available to both citizens as well as non-citizens. Okay, Article 21 is available to both citizens and non-citizens. See, Gopalan case of 1950, the Supreme Court has taken a narrow interpretation of Article 21. It held that protection under Article 21 is available only against arbitrary executive action and not for arbitrary legislative action. Okay, in Gopalan case, Supreme Court said that protection under Article 21 is available only against the executive actions and not on the legislative actions. What does it mean? This means that state can deprive the right of life and personal liberty of a person based on law. Okay, Supreme Court said that in Gopalan case. But in Menaka Gandhi case, the Supreme Court overruled its judgment in the Gopalan case by taking a wider interpretation of Article 21. It introduced an American expression, due process of law. Okay, the protection under Article 21 should be available not only against arbitrary executive action but also against arbitrary legislative action. This was said in Menaka Gandhi case. Earlier in Gopalan case, Supreme Court said protection under Article 21 is available only against executive actions. Only against executive action and not in the legislative action. In Menaka Gandhi case, it said protection is available not only in the executive action but also in the legislative action. Okay. Next. Right to education. Article 21A declares that state shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state may determine. Okay, Article 21 declares that state shall provide free and compulsory education to all the children of the age 6 to 14 years. Thus, this provision makes only elementary education a fundamental right and not the higher or professional education. Okay, this provision was added by the 86th Constitutional Amendment Act of 2002. This amendment is a major milestone in a country's aim to achieve education to all. Government described this step as dawn of second revolution in the chapter of citizens' right. Okay, government described this step as dawn of second revolution in the chapter of citizens' right. Education for all. Next, even before this amendment, the Constitution contained a provision of free and compulsory education to children under Article 45. Okay, under Article 45 in Part 4, that is DPSPs, Constitution contained a provision for free and compulsory education for children. But as it was under Part 4, that is in DPSPs, it was not enforceable by the court. Later Article 21A was included by 86th Constitutional Amendment Act of 2002. Okay, however, being a directive principle, it was not enforceable by the courts. Now there is a scope for judicial intervention in this regard. Okay, earlier as it was in DPSPs, it was not enforceable by the courts, but now it is included in fundamental rights, so there is a scope of judicial intervention. Okay, next. Protection against arrest and detention. Article 22 grants protection to persons who are arrested or detained. Detention is of two types, punitive and preventive. Okay, Article 22 grants protection to persons who are arrested or detained. Detention is of two types, punitive and preventive. Punitive detention is to punish a person or an offence committed by him after trial and conviction in the court. Punitive detention is punishing a person after he commits a crime, whereas preventive detention is detention of a person without trial. Okay, arresting him without a trial and conviction by the court. Its purpose is to punish a person for a past offence but to prevent him from committing an offence in the near future. Okay, the purpose of preventive detention is not to punish a person for his past offence but to prevent him from committing an offence in near future. Okay, this preventive detention is only a precautionary measure. It is just a precautionary measure, but not to punish a person for his past offence. Next, the Article 22 has two parts. First part deals with the cases of ordinary law. Second part deals with the cases of preventive detention law. So the first part of Article 22 confers the following rights on a person who is arrested or detained under ordinary laws. Okay, Article 22 has two parts. First part deals with the ordinary laws and second part deals with the preventive detention law. The first part of Article 22 confers the following rights on a person who is arrested or detained under ordinary laws. See, right to be informed on the grounds of arrest. If a person is arrested under the ordinary law, he is given a right to be informed why he is arrested. Next, right to consult and be defended by the legal practitioner. Okay, he can consult and he can consult a lawyer and he can be defended by a lawyer. Next, right to be produced before magistrate within 24 hours excluding the journey time. Okay, right to be produced before magistrate within 24 hours and the journey time is not included. Next, right to be released after 24 hours unless the magistrate authorizes future detention. If the future detention is authorized by the magistrate, then he is made to stay more than 24 hours. If not, then he should be released after 24 hours. Okay. These are the rights on a person who is arrested under ordinary law. Next. Second part of Article 22 grants protection to persons who are arrested or detained under preventive detention law. This protection is available both to citizens as well as aliens and includes the following. Preventive detention law. Protection against this is available both to citizens and aliens. Now what all are included? Let us see. The detention of a person cannot exceed 3 months unless the advisory board reports sufficient cause for extending the detention. The board consists of judges of High Court. See, the detention of the person cannot exceed 3 months unless the advisory board reports. Unless this advisory board reports, the detention of the person cannot exceed 3 months. If the advisory board says that the person is detained for more than 3 months, then the detention is exceeded. Okay, this advisory board consists of judges of High Court. Next, the grounds of detention should be communicated to the detainee. However, the facts considered to be against the public interest need not be disclosed. Okay. the reason for his detention can be communicated to him. But the facts, if the facts are against the public interest, then they need not communicate with the detainee. Else the facts can be communicated to detainee. Next, the detainee should be afforded an opportunity to make the representation against the detention order. Okay, he is allowed to give an opportunity to make the representation against the detention order. Okay, these all are included under the protection of a person under the preventive detention law. Next, Article 22 also authorizes the Parliament to prescribe the circumstances and classes of cases in which person can be detained for more than 3 months under the preventive detention law without obtaining the opinion of the advisory board. See, earlier we have seen that the person who is detained under preventive detention law, he can be detained. The person who is detained under preventive detention law will not exceed more than 3 months. But his punishment can be exceeded more than 3 months if the advisory board decides. Right? But here, Parliament is given the higher superior authority. So here Parliament can prescribe that the person can be detained for more than 3 months under the preventive detention law without the without the opinion of advisory board. Okay. Next, the maximum period for which a person can be detained in any class of cases under the preventive detention law. See, Parliament can also prescribe the maximum period for which the person can be detained under preventive detention law. Next, the procedure is to be followed by the advisory board. So whatever Parliament says, that should be followed by this advisory board. Okay. With this, we are done with the right to freedom. In the next class, we'll deal with the right against exploitation and right to freedom of religion. Thank you.